Supreme Court is effectively saying that smaller benches or similar sized benches have diluted the K.A. Najib judgment. Is this a rare institutional correction by the court itself? How important is this for both sides of the bar? If the trial itself takes 5 to 7 years, should the accused remain jailed throughout? What's your assessment and standing on this?
See, as far as the question of the bench, questioning its earlier order passed by a smaller bench or a larger bench, this is not the first time that Supreme Court has done this. Supreme Court has been reconsidering or has been questioning its earlier judgment. Keshwananda Bharti was the best example where the Constitutional Court of the 5 judges, then the 7 judges, then the 9 judges, and the 11 judges, it was referred to. So it is always that Supreme Court can review its earlier judgments if the later benches find that the earlier judgments were perhaps not correct in law. Then in the interest of justice, these can be reviewed. Now, as far as the question of UAPA bail is concerned, here it is not a simple case of bail.
Then, Dr. Nanda, why talk about dilution? Why use the words like sidestepping by Justices Nagaratna and Ujjal Bhuyan? I mean, help the viewers understand. Why use those particular adjectives this time around?
So it is not, no. It is don't go by the words literally, diluting and all that. They were only saying that the 2-judge later bench cannot see the earlier 3-judge bench, cannot overrule it in a way that they can take a different view. So it is not the question of diluting, maybe looking at it from a different angle. That was the point which the bench was making. It is not that saying diluting doesn't mean literally here. It is only a question which the present bench has raised, that the earlier 2-judge bench, which they are saying has been as said diluted, has looked into the law of bail by the Supreme Court 3-judges bench in a different way. So they say that this cannot be done. If it is to take a different view, then a larger bench has to be constituted. It was earlier the main judgment was by 3 judges, then it should be referred to perhaps 5 judges. This is what the current bench has held.
But Dr. Nanda, you see, when it comes to the UAPA, it's always, embroiled and tangled with a lot of politics. We're going to keep that aside. Let's look at the legal aspect of it all. If conviction rates are so low when we're talking about the UAPA, are we over-incarcerating? What's your assessment on that front? Is suspicion becoming sufficient for years of imprisonment? I mean, these are the questions that came up today after the hearing.
The UAPA is an act which has been legislated in a way that till the time it is there on the legislative book, you can't help it. There are 3 bars. It is unlike the normal case of bail, where the longer incarceration can entitle accused for bail, or the bail is the normal rule. The incarceration should not be there during the trial. UAPA minded, there are bars under 43D. The prima facie bar is there. That if the prosecution prima facie establishes before the court that the person charged is guilty, that minded the word is only prima facie. The prosecution may not be in a position eventually to get the conviction because of lack of evidence. But if they prove prima facie that there is a case, then yes, the bail can be denied. Then there is a second thing which is not there in the normal cases, which is called the prosecutorial veto. The public prosecutor has to be given a fair chance to oppose the bail, that this is a case where the UAPA is applicable and the person charged is guilty. And the third one is, of course, the burden here is in a reversed way. Normally, it is on the prosecution to establish that the person is charged, the person charged is guilty. Now, here in the UAPA, the burden is reversed. It is for the accused to say that, no, look, what I am charged with is not the prosecution's case is not correct. I am innocent. So the normal rules are not applicable here.